This is the third petition now that I'm saying that will be by the father, by the son. This is the first petition by the mother arising out of the same loan transaction. It has been dismissed by your lordship's court. It has been dismissed twice by the Supreme Court. Giving a liberty under section 17 of law. It was everything but rights and liberty under section 17 of the Supremacy Act. So my friend says this relation is far by the doctor of listening question, right? For the doctor receiving it at the reply.
It's not a question of res judicata. If you have an alternate remedy available under section 17, Mr. Nedumbara, you hear the court. If you don't want to hear the court, then Mr. Nedumbara, we are the division bench here. You have to hear the court. You cannot interrupt the court when the court is. Mr. Nedumbara, if there is alternate remedy under section 17, you are well advised to go there. Yes, there is no question of res judicata. Yes. You answer whatever you want, yes.
Is a foreign disease, we are supposed to use it. The primary reason is the rights which I accept, which I worship my memory or against me, are created by the MSMA Act of the Notification Act by and the statute provides for certain rights in my time, in addition to what is recognized by the common law, and certain class of obligations and liabilities of the respondent party. And the Act does not provide any mechanism for enforcement of the rights or ratification of the dispute with relation to the amendment of the notification, and therefore the civil court jurisdiction is not understood. Now, that is first thing of the argument. Second thing about the argument that the majority of the Act does not outstrip the jurisdiction of the civil court, and it has been repeatedly about that the Supreme Court on a number of occasions. And the reason I offer it now is that two reasons. It's a fundamental principle of law that tribunals cannot grant information to the law. And the first tribunal, if I am not wrong, which was made in this country is the tribunal of the Income Tax Act. The tribunal made under the Income Tax Act under section 66. Let me say what I request for the one to say that I go to the meetings. Under this section 66 of the 1924 Income Tax Act, the subject as well as the collection authorities, what can make a request of a reference to the High Court of any question law. Because a question law, the tribunals cannot be done. But yes, the section is given the Washington section 66 of the Income Tax Act of 1922.
So Nedumbara, why are you transgressing to the Income Tax Act of 1922? Have you seen the bar of civil courts under the Act?
If I am not allowed to answer, there is no point. If I is the repetition, so once you there is a possible because this court, why does not now this is the repetition? My case in this case, after hearing in this case, who has allowed to dismiss it? But because you dismiss it here, it is the relevant of the law. I am saying that for that all your contentions be upheld. Then the case will be decided against me. I am prepared for that.
Mr. Nedumbara, if you are wasting the court's time, yeah, heavy costs will be imposed on your client. Heavy costs will be imposed.
I'm not saying do it.
Supreme Court has passed an order against your client. Why should we depart from the view taken by the Supreme Court? Mr. Nedumbara, why should we depart from the view taken by the Supreme Court?
Let me answer. I'm answering. Supreme Court has not said
page 74 is an order of the Supreme Court of 28 July 25. Needless to observe, the petitioning enterprise will be at liberty to pursue its remedy under Section 17 of Surfacing Act. No, we are showing you a lot of indulgence. We don't want the court's time to be wasted. We will say what is right.
I'm only answering your question. And if your lordship say
There's an order of the Supreme Court.
No, shall not be inserted. That is a problem. Because I'm here to clarify your lordship. Your lordship asked me a query. I'm answering it.
You are going into a 1922 Income Tax Act, which is totally irrelevant.
No, I am allowing to say complete what I wanted to say. The fundamental principle is that tribunal cannot decide a question of law. That is therefore under the Income Tax Act of 1922, there is a provision for the High Court. Under the Income Tax Act of 1961, also there is a provision for the High Court. Section 256 and under Section 268, in 2020, the Income Tax Act was amended, providing for a direct appeal to the High Court. And therefore, under the Income Tax Act, there is a provision for a reference of a question of law to the High Court and High Court decided the question of law. Under the Recovery of Debts and Bankruptcy Act, there is no provision for a reference to the High Court. But the jurisdiction of the Civil Court is from outside, and that is what Supreme Court has said previously. Market Industries case, then see the case which I only argue. This is Sanjay Krishna's court statement. This is Ramal Shah's statement. Sanjay Krishna's court statement, Article 52. That the jurisdiction of the civil court is from outside. And as the reason I explained, these are against me, but give me these are against me. I am more than prepared to be lost. Because I am not this kind. See, I am only representing somebody. This is against me, I am getting no fun. That is a consequence. That is the consequence of litigation. Most of the cases I said that it's not borrowed. I only said that I only running one is like 50. What I my action is one, is what should understand what I wanted to say. What is my argument? I reject it. If it is a given reason, reject it. That's all.
Yes, Mr. Nedumra, you go on with your argument.
Yes. Section 17. I have been provided the lordship. I have always been provided to people when somebody is not providing me on the level of the way of the blood and dialogue here. That is a right that I have not space for Lord. You are depending to ask also.
Mr. Nedumra, please address the matter. Please address the matter. Yes. Yes.
Section 17.
Madam, give me the 17.
Section 17 of the Recovery of Debts and Bankruptcy Act.
Madam, give me 17 of Recovery of Debts.
Is that a 50?
Give us 17. Yes.
Yes. Section 17.
Yes. Yes. Yes.
Tribunal shall exercise upon and from the following day the jurisdiction, powers, and authority to entertain and decide applications from banks and financial institutions for the recovery of debts due to such banks and financial institutions. So the tribunal was exclusively for the banks. Therefore, the banks are against the borrower. And not of the borrower's right or claims asked from against the borrower is not provided for. So, your lordship, I take up section 19 fully. Very distinct. Very bare minimum. Section 19. Section 19. Wherever a bank or financial institution has to recover any debt from any person, it may make an application to the tribunal within the government which is opposed to the jurisdiction. That means the bank secretary, the defendant decide, but the conservator, etc. So this section 19 and section 17 says, this is the ERP is exclusively for the
Yes.
Funds and finance institutions. And then in 1995, the Federal Court of Appellate Association filed a petition saying that this is a bad law.
Yes.
And the Supreme Court, so the Federal Court accepted the convention and recognized the entire amendment.
Yes.
Only it is one-sided. And it does not provide for a mechanism for adjudication of the claims of the borrower outside the bank.
Yes.
Then when I take the machine to section 19(6), this is by the amendment, which was brought in 2000.
Yes.
So the machine gets passed. Section 19.
Yes.
Fine.
Yes.
And all that I can, so really I can just say what is it?
Yes.
So this one is 19(6). Yes. But subsection 6. Where the defendant, your machine code?
Yes.
Where the defendant claims to set off the applicant's demand any ascertained sum of money legally recoverable by him from such applicant, the defendant may have the first hearing of the application, but not afterwards, unless permitted by the tribunal, present a written statement containing the particulars of the debt so to be set off, along with the original documents and other evidences related on the support of the claim of set off in relation to any ascertained sum of money and expectation. That is one of the many educatable remedies. Next. The written statement shall have the same effect as explained in a clause so as to enable the tribunal to pass a final order in respect of the original claim and the claim was settled. Then, section 8. A defendant in an application claim, in addition to his right of reading of settled under section 6, set up by way of a counterclaim against the claim of the applicant any right or claim in respect of a cause of action, accruing the defendant against the applicant either before or after or the value of the application, but before the defendant has delivered his defense or before the time defendant for delivering his defense has expired. What is a counterclaim is in the nature of a claim or for damages or wrong. Section subsection 1. A counterclaim under subsection 8 shall have the same effect as a clause rule so as to enable the tribunal to pass a final order in the same application on of the original claim and on the counterclaim.
Yes.
Then section 10. And the applicant shall be reverting to file a written statement in answer to the counterclaim of the defendant within such period as the case as in this case. Then 10A. Every application of subsection 3 or written statement of defendant under subsection 5 or a claim of set-off under subsection 6 or a counterclaim under subsection 8 may be by the defendant or a written statement by the applicant in reply to the counterclaim or under subsection 10 or any other pleading whatsoever shall be supposed to make applications only by the applicant or the defendant verifying all the facts of the pleading. The statement, the statements, various documents, and other documents attached to the application or the statement, or requiring to set off or counterclaim as the case may be. Provided that there is any evidence of extra then around 10B. Yes. If on the facts of the agreement, the application of the statement are not verified, then subsection 1. Yes. Where a defendant set off a counterclaim with a written statement and in replying to such claim, the application is done.
Yes.
Combines that the claim thereby raised ought not to be disposed by way of a counterclaim, but in an independent action. The tribunal shall decide such issue along with the claim of the applicant or before the case. Yes. Where the minister of the proceeding tribunal or an application made by the applicant along with particulars of the property to the cannot be. Now, based on this statement came from the Supreme Court, whatever justice. This scenario that is lender is obligated to mandatorily obligated to file a suit commonly called as OA of the application in the ERP for recovery of whatever account is related to suit.
Yes.
And the borrower, if he has a counterclaim set of a real educated or release office available to him, he is permitted to seek the in the OA bank scheme.
Yes.
Then he is also free to institute an independent suit because the jurisdiction of the civil court is not outside. And if the borrower makes a counterclaim, it should be treated as a counter suit. If the bank finds that yes, this has to be decided by the civil court or by the tribunal, then the bank can say that claim will be decided in an independent proceedings in a suit. So therefore, this is the scenario. Civil court jurisdiction is not outstretched. Even in a case not involving MSME Act and the notification dated to the next by 2015, that is the law. This is the sensitive law.
Yes.
Because long time of decision, there are either judgments, but
No, Mr. Nehru.
once again,
Mr. Nehru, has a 13-2 notice has been issued in this matter? Has a 13-2 notice been issued in this matter?
yes.
Now, if a 13-2 notice is issued, wouldn't the SURFACE Act apply?
No, but that is not this issue. I will not answer legally, and you will watch it. I will not take it into account. Now the issue is, I am not seeking, I am not attacking, I am not primarily surprising. What I seek is that the entire proceeding, the classification of my account as a PA is in violation of the notification dated 29 by 2015. And the notification dated 29 by 2015 as set out by the individual computer and brought the economy association of its 1 second block. This is a continuation of this information of this. Because it was doubly clarified paragraph 15. Yeah. I am better against statements because it doesn't longer and solely based on time. So, fundamental principle I want to go back fundamental principle. Statement of comments.
Yes.
Because it is time I am going to argue for article. Where to all courts say the dismissal system because only committed as a committee. Paragraph 56.
Paragraph 56.
56. It is also to understand that we must recognize me as occupiers as a writer of jurisprudence, reading jurisprudence. If I am able to look at it, that will maximum as
Yes.
then what my child will be 20 comes to the young age of seminar and always has studied law. Seminar and become an engineer. Now maybe I have to join law and become an engineer. Seminar as a student of law, seminar was this. I'm student of law.
I understand that.
Yes. Similar, they may take the paragraph 56.
Yes.
56.
Yes.
In the discussion at fourth section, the question paid above are to be answered as well. Is this jurisdiction of a civil court to try a suit filed by a borrower against a bank or financial institution outside by the issue of the scheme or the recovery against a bankruptcy act in relation to the proceedings for the recovery of wealth by a bank or financial institution? The first question ought to be answered first, and it is answered in the negative because it was simple outside. Then next is whether an independent suit filed by a borrower against a bank or financial institution which has applied for the recovery of his loan is gone against the plaintiff under the recovery against a bankruptcy act. His liability transferred and right along with the application of the RTP Act by the RTP. Yes. In the absence of any such power existing in the civil courts, an independent suit filed by the borrower against the bank or financial institutions cannot be passive to be tried along with the application of the recovery against a bankruptcy act, as it is a matter of option of the defendant in the claim under the RTP Act. Yes, well, however, the proceedings under the RTP will not be an impediment in the manner of the separation of the civil court. Now, this is fundamental principle. This is we have got legislative transfer as lawyers. Here, we don't have the legislative transfer. We don't have the it is impossible when the entirely the rights and obligations are two-sided, when the entirely is two-sided, it is impossible to also jurisdiction of the civil court. I take your Washington Durham.
No, Mr. Nedumra, that is not necessary.
The civil court jurisdiction is
yes.
it cannot be understood for three reasons. first and foremost, which no judgment has ever answered except the Madras High Court judgment, that the rights and obligations arise out of the MSN media, which I observed dispute, cannot be decided by the BRP in aspect as the MSN media and the notification, which is a substantive law, has not confers and dispersed powers in BRP. And then the question is whether such powers will be inferred by the answer is it cannot be inferred as well because the jurisdiction under section 13(2) is narrow. I take the notion to section narrow 13(2). It is a section 13(2). It is a very narrow. It is if the property, if rather the jurisdiction of the BRP was larger in scope, then it could be argued that yes, MSME Act expected from having explicitly covered jurisdiction of the BRP, saying has been implied. But implication is also difficult because you can take no logic to section 32. That leads to the cases. Where in the borrower who is otherwise identity to a security under a security agreement makes any default in the payment of a security or the installment of their own and is account in respect of such thing is classified by the security as a non-performing asset. Then the security may require the borrower by notice inviting to discharge the full list of the government release rest. So, this MSME, the Surface Act is of 2002. The concept is contemporary supposition, optima is gajing. When you implement this section, what we have in mind is what was the intention of the legislation.
Yes.
And this was confined to the narrow, security interest. See, MSME, the scope of MSME is far wider. See, I am an MSME, and MSME communications, etc., and the etc., often like that, not be given without any collateral security.
Mr. Nedumbara, that this argument of yours on MSME has been considered by the Supreme Court.
No.
It is that Proceedings versus Canara Bank has been referred to. Let us consider that argument.
No. Proceedings versus Canara Bank decision didn't come.
It is only to that issue.
Only versus Canara Bank, what was the issue before that? The Bombay High Court now very erroneously established as the interest scheme. My contention before the listen to me, I will be rushing your rushing read my contentions honestly. Because I am totally wrong at the happiest time. I always, somebody who doesn't this. Because they have sold out the mistake or something.
Yes.
So therefore, the logic reject my plea, but provided there are some reasons to reject it. And if there are good reasons to not to reject it, don't reject it. That's what I mean.
No, that is the case.
And another technical issue about the notification is another section. Because this is an issue, it's connecting most people. So there are record. There are rights already marked. That's not the Supreme Court. Right hand, it is subject to become like all the Supreme Court. That your lordship judgment is not the law of the land. Your lordship judgment against the truth, we are handing by hand only. And you do not bind the hand who are not parties. Because the doctor doesn't do as authority, it is not my creation.
Yes.
The doctor doesn't do as authority, not the so that's the principle of nothing. I am not bound by a judgment of the I am not a party. Please not ask me what sound principle. That principle, that principle when repeatedly and immediately above, that principle is something I worship the concept of reason. But abuse of reasoning is no statute can be any substitution of no judgment can be any substitution of that. No judgment can be read as a statute. If you allow that, then you go back to the dark ages.
Not a question of statute.
Judgment is the interpretation of the statute. Here, what was the issue? Demonstration has been obligation in civil education. You make it understand. And the notification says, if that you have to, this is a long kind of notification. Because MSM is a peak, and the government considers it is in the interest of the economy and in terms of development, birth, etc., that the banks and financial institutions will make a proactive approach and reach out to the MSMEs, identify the sequences so that no industry is more MSMEs. And assuming that they fail, when they notice then don't classify the account as NPA, go to the committee, make a report for resolution officer, then everything is permitted. And the last time to argue that Surface Act is not applicable. Surface Act is very much applicable.
Yes.
IPC is very much applicable. See, that is only I take a worship 1 second to prepare something. Just possible. Many times the people misunderstand. They stop on the act, Surface Act is applicable. IPC is applicable. I never said such a condition. But take a motion to make something.
Section number?
I'm trying to give asking the time as possible.
No,
Page
73 of this book.
This book.
Page 73.
77.
Yes.
What's the first two options? And A is one of rectification. That involves banks to put further money. B is restructuring. The money is established 20 years, 15 years ago. Yes. Then 3 is what of recovery. What's the first two options? And A, rectification, and B, recovery. Above are seen, not feasible. Your recovery process may be the sort of two.
Yes.
Your recovery process may be the sort of two. The committee may decide the best recovery process to be followed among the various legal and other recovery options available. So they are due to optimizing the efforts and results. So the committee can well permit recovery. So I don't say that MSME Act is because somebody is right, so that somebody should write that. I have never said MSME Act in a regular law will prevail on the Surface Act. No. The concept of just procedure was formally applied has no application. This MSME Act and the Surface Act both survive. Both can coexist. There is no contradiction.
Yes.
The MSME Act does not override or abrogate the Surface Act. No, I never said it. It coexists. And the mechanism, your worship is surprised and mind. Surprised and mind, the amount of government India has put.
Can I ask you a couple of questions, please? Your son is the proprietor of, what is the name of his?
Please say, Swami is our construction and finance solution.
So he is your son. He is your son.
Yes.
If you turn to page 74,
Yes.
Exhibit G,
Yes.
this is the judgment of the Supreme Court on 28th of July 2025 in the proceeding which is filed by your son in respect of the very same property.
Yes.
Now turn to page 81,
Yes.
Exhibit H.
Yes. There is one more judgment. You get this Supreme Court again. Again, once again it was dismissed. Yes. I was trying to
One dismissal is enough.
Yes.
Multiple dismissals will not make it. Now, what is on page number 81? Again, your son came to this court and filed a writ challenging the very same action in respect of the very same property.
Yes.
And there is correct. I am just clarifying. So 6th of August, there was an order passed by the division bench dismissing the writ that was filed by his son.
Yes.
So now this is round 3.
No, yes. I tell you, another case, I went to a job. 57 80 proceedings. It is one of the has consulted doctors only in the detailed court has referred to that consulted doctors only in the This kind of dependence, even if a litigator had to go into 28 times, 158 proceedings, that is the failure of the system.
But this is not the same litigant who's going. This is different litigants who are going.
Court has no power. No power to allow the law. It will not find.
Mr. Nedumbara, how does the petitioner have locus to file this petition?
It is my problem.
No, but
I am a Tamil who is
who is a MSME under the MSME?
my son.
So your son is the one who is locus to file this.
So my son is the one who is an MSME. I am the one who.
How does the petitioner file this petition?
No, I have a right. You have a right.
Who mortgaged the premises?
I mortgage.
You or your son? You or your son?
No, there is no family. Yes. I, the mother, stood as guarantor for the law taken by my son. I am where the under the surface here and the borrower. Borrower includes guarantor also is a borrower. I am liable.
Who was served the notice under section 13(2)?
The notice under section 13(2). It has been acknowledged and will not then be noted. Questions of right and no basic notice. Questions of right and no questions of right and legal worship just have to read the Brunet's statement. There is a questions of right and no basic in the Brunet's judgment.
Yes.
Okay, challenge to the classification or identification of an incipient asset has to be made prior to classification of that loan account as an NP.
Yes.
That has been further clarified in the subsequent judgment which even after notice issued. Let me complain get an opportunity. I said my complaint will not be justice.
Mr. Nedumbara, this is the third innings. You can't have more than three. In fact, in cricket, you can't have more than two innings. You are in the third inning. Mr. Nedumbara, it's absurd.
Yes.
In cricket, you have two innings.
No, my brother, that will not be Exhibit G, that is the judgment of implementation by 684 of 2025 Exhibit G at the hands of Justice Divangar Datta and page Exhibit N at the hands of Justice Advocate Justice Walker. I think instituted by my son will constitute a bar.
We are not
If it constitute a bar, I'm out.
We are not talking about
If it is constitute a bar, I'm out.
Mr. Nedumbara, we are not talking about disputicata. We are talking about discipline on the part of your
No, there is
client
nothing. Sitting in a bar, sitting in the concept of studicata, go visitate, affiliate. Judicial member, go visitate, affiliate. If the court has decided 1 + 1 is 0, I am bound. I am bound. That is no. I am bound.
Mr. Nedumbara, can you look at paragraph 18 of your petition?
But anything of my petition.
1(8).
Okay, so my petition.
That's right.
Yes. So
The last sentence in this paragraph.
If the studicata, I am out.
I'm not.
If the studicata, I am out.
If you see paragraph 18,
Yes.
you made a statement to say that no notice 32 was served upon you.
Yes.
Are you standing by this statement?
No, let me answer that. I stand by that, but before this court dispute the questions of fact, I don't want to release. Dispute the questions of fact, that is another.
How is there a dispute? I'm asking whether you are standing by the statement.
That is my stand.
That's
But
all.
I'm not raising any question of fact. Because usually the forum under 226 is called the forum under 226 is called the forum to decide dispute the questions of fact. And I have called the postman and the query has been conducted. And I have tried on the thing.
Mr. Nedumbara, if you are making a false statement, there is no question of the court at all entertaining your case.
No.
No, because in para 18, you have made a false
Copy. Please give
in
a
para 18, you have made a false statement
Who said
that no notice was served upon the petitioner. Your client has signed a notice under 13(2).
No, therefore somebody has to say was an affidavit saying that my client.
Let us take down writ petition. I've heard you. Writ petition lodging number 279444 of 2025. Next. Oh, Mr. Nedumla, I'm throwing you out and I'm imposing costs. By this writ petition. Mr. Nedumla, I will tell the security to take you out. By this writ petition, the petitioner is challenging the proceedings taken under surfacing by the respondent bank on the ground that the petitioner that the section 14 on the ground that and has sought that the recovery proceedings initiated by respondent numbers 1, 2 and 3 under the Surfacing Act are void ab initio, stillborn and without any legal basis and consequences. Full stop. A further declaration under section 14 of the Surfacing Act that it is unconstitutional and violates and is void is sought. Full stop. Next. The petitioner has in paragraph 18 of the writ petition stated that the 13-2 notice issued under the Surfacing Act has not been served upon the petitioner. Next. The Learning Council appearing for the respondent bank has tendered the section 13-2 notice issued on 5th August 2023 to the petitioner, and which notice has been signed by the petitioner as co-borrowers to mortgagor. Thus, the averment in paragraph 16 of the writ petition is paragraph 18 of the writ petition is false. Next. Further, we have considered that the petitioner's son, who is the borrower from the respondent bank, has and which has filed earlier proceedings, earlier writ petitions, including writ petition civil number 684/2025 before the Supreme Court of India, wherein the same contentions have been raised as have been raised by the petitioner herein, including the applicability that the surfacing proceedings ought not to continue against the petitioner's son, whose firm is a MSME registered under the Micro, Small, Medium Enterprises Development Act, 2006. MSME Act 2006. This petition had been dismissed by the Supreme Court by holding that no case for interference under Article 32 of the Constitution has been set up, and that it is needless to observe, the petitioning firm stroke enterprise will be at liberty to pursue its remedy under Section 17 of the Surfacing Act. Next. In yet another writ petition, being writ petition lodging number 21202 of 2025, filed by the petitioner's son against the respondent bank in respect of the very same subject matter as in the present petition. The division bench of this court, dated 6 August 2025, in the petition number 21202 of 2025 has considered a earlier decision of the Supreme Court and information decision of the Supreme Court and has held that it would not be open for the division bench to examine any of the contentions raised in the writ petition and argued by Shri Nedumbara in view of the authoritative pronouncement of the Supreme Court in the aforementioned decision. The decision of the Supreme Court is binding on this point. It was further the request made by Shri Nedumbara to protect the petitioners for some time was rejected on the ground that the Supreme Court in the said order dated 28 July 2025 had granted liberty to petitioners to pursue its remedy under Section 17 of SARFAESI Act 2002 and Act 2002. Stop. Next. This is the third inning. Which the petitioner's son through the petitioner has filed has third innings which the petitioner's son through the petitioners is pursuing by way of the present writ petition. The petitioner has exhausted all possible remedies to agitate its contentions in writ proceedings before the Supreme Court and as well as before this court in order to restrain the respondent bank from taking possession of the subject tenement property and obligor to dispose the petitioner from the suit property under the SARFAESI Act 2002. The petitioner's son, who is behind the petitioner, is nothing but a vexatious litigant, and this court cannot entertain any further proceedings filed by the petitioner's son or the petitioner on the same subject matter, which has already been considered by the Supreme Court and the division bench of this court in the aforementioned decisions. Next, this writ petition, which seeks to make the contentions already raised before the prior courts, including by placing reliance upon the Recovery of Debts and Bankruptcy Act 1993, the Micro, Small and Medium Enterprise Development Act 2006, and the SARFAESI Act 2002 cannot be further entertained in view of the Supreme Court having directed the petitioner's son to avail of remedies under Section 17 of the SARFAESI Act 2002. Next. In view thereof, the writ petition is dismissed with costs of rupees 50,000, which shall be paid by the petitioner to the respondent bank. Yes.
Yeah, Dr. Lawyer has been accepted.
No. Mr. Nedumbara, you are for 50,000 costs. Yes.
The lawyer has been accepted.
Right.